one of which being a member of Shannon Aaron is proposed to begin in public session. Is that agreed? Agreed. You're all very welcome to this meeting this morning. Just at the beginning, yesterday the committee was informed by the Bar Council that it wouldn't be attending today. I'm therefore proposing that we reduce the length of session 2, as we've only one group in attendance, with 10 minutes for opening statements, 50-minute questions, 35 minutes for members of the committee, 15 minutes for non-members, followed by a final 5-minute statement by the witnesses. This will bring session 2 to an end at 12:50 and we'll adjourn until 2:45. Is that agreed? Agreed. Okay, this is the 5th session in a series of hearings that the Joint Committee are conducting over a period of 3 days to discuss the implementation of the government decision following the recent publication of the expert group report into matters relating to cases ABC versus Ireland. Yesterday we began our hearings primarily at medical issues and the concerns of medical practitioners. Each of our 4 sessions was constructive and there was positive engagement between members and witnesses, which yielded a very interesting and significant debate. At the commencement of today's session, I would like to reiterate that the purpose of our meetings is to discuss the implementation of the government decision following the recent publication of the expert group report into matters relating to cases ABC versus Ireland by way of legislation and regulation within the parameters of our current constitutional provisions. Government has stated that its aim of its action in this matter is to ensure clarity and legal certainty in relation to the process for determination of whether a termination of pregnancy is permissible in cases where there is a real and substantial risk to life as opposed to the health of a mother, of a woman as a result of that pregnancy. In doing so, we must ensure that we take full account of Article 43.3 of the Constitution. So with that, I want to welcome this morning to our meeting Ms. Jennifer Schwepp from the University of Limerick, Ms. Ciara Staunton from NUI Galway, and Dr. Simon Mills from the Law Library.
Just in relation to the Bar,
I'm not going to have any debate on it if you can.
But okay. I think it should be clarified from the point of view of the clerk, because I think in fairness to him, it was clarified that the Bar Council were prepared to come in, and I think it's wrong now that it's out in the public domain that they never agreed to come in. But in fact, it was clarified to him that they intended coming in. And I think that should be clarified.
I'm not going to get into a matter of dispute with the Bar Council. I'm not getting into it this morning.
No. Would you allow me just read a point of order on that, just very briefly?
No, I'm not going to allow it. I'm not going to allow it, Deputy Senator Walsh. The matter is agreed. We've moved on.
It's not about the Bar Council, actually. It's about the ICCL giving them 2 hours.
I've made a proposal. I've made a proposal. If you were here on time, you'd have heard it. We're reducing to 1 hour the session. Okay, thank you. Yeah. And we will begin our meetings on the button at the time appointed. I'm a very prompt chairperson, and I'm going to be respectful to all people, but we're going to start bang on time. Okay, thank you. I think Deputy Senator Burke, we've dealt with that matter, and we're clear in our own situation. I'm not going to get into a war of words with anybody, because if that's okay with you there. Okay? Before we commence, I want to remind witnesses and members regarding privilege. Witnesses are protected by absolute privilege in respect of the evidence you're to give to the committee. However, if you're directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you're entitled thereafter into qualified privilege in respect of your evidence. You are directed that only evidence connected with city matters these proceedings to be given, and you're asked to respect the parliamentary practice effect that where possible you should not criticise nor make charges against the person or persons or entity by name in such a way as to make him or her identifiable. And members are reminded of the long-standing parliamentary practice to the effect that members should not comment on, criticise nor make charge against a person or persons outside the House or an official either by name in such a way as to make him or her identifiable. So with that, I want to call on Ms. Jennifer Schwepp to make her opening remarks, and each witness is 10 minutes, up to maximum 10 minutes.
For the invitation to present. I'm fine. Thank you for the opportunity to present here this morning. In my written submission, I've set out 6 substantive issues which I think need to be addressed by legislation on this issue. In my written submission, I've also highlighted some ancillary issues, some which would relate to issues already in some way looked at by the courts, such as travel and information, and some which address issues which have not yet been courts, and I'll talk about those at the end. I'm basing my submission, as I've based all my academic writing, on the assumption that what we're doing here is legislation for Article 43.3. I'm not here to question its presence in the Constitution. I'm simply here to talk about how do we fulfil our obligations, which are set out in the Constitution. I also base my submission on the law as it's established and the Constitution as it is interpreted. So I'm not here to question the findings of the Supreme Court in the X case. nor indeed in any other case, but I will highlight some lacunae as I see them in the law or inconsistencies in judicial pronouncements where they're appropriate. There has been some talk in relation to the risk of suicide justifying termination, and on this I think that X is the law. There's no room for debate on this issue in relation to the issue of suicide. Only the people, through a referendum, or the Supreme Court on appeal can change this position. Further, I'd say that it's insulting to women to say that they're going to flock to doctors to assert suicide in an effort to pull the wool over their doctor's eyes simply to get an abortion. And it's further more insulting to the medical profession to suggest that the wool will be pulled over their eyes.
Sorry, just the sound I think is wrong there. It's not coming out in the mic. It's not coming out in the microphone.
Is my bump in the way?
Slightly, if I lift this, you just step back slightly, just like.
Can you hear me now? The medical profession to suggest that the wool will be so easily pulled over the eyes of doctors and practitioners working in the area by these women. I also think that it's dangerous for politicians, for members of the clergy and doctors to trivialise the issue of suicide, particularly in a country which has a clear issue with suicide, particularly in the context of teen suicide.
Sorry, Senator Walsh, sorry, Senator Walsh, have a small level of decorum, please.
But
Sorry, I'm not going to tolerate interruption and bad practice in this committee meeting. Okay, please now show the courtesy and respect to not just the witnesses but to the members of the committee. I'm not going to have a debate with you. I'm not going to have a slagging match with you. I'm not interested in that.
Yeah, I'm not interested either.
So stop, please.
But I spoke to the clerk last night about the content today.
Sorry.
Of what we're getting your opinions.
Senator, you're out of order and you know it. If you could move, Mrs. Sweat, please. Your microphone isn't working. So
Right, sir.
thank you. If you could just move down one, please. Thank you.
Okay. Am I okay now?
Yes, thank you.
Right. Okay. So that's the first thing that I'm not going to talk about. The other thing, no. These microphones are too small.
I think you're banging me off the button.
Oh, that's.
There you go.
Oh, it's my bump.
I'm sorry.
Okay.
And
Is
thank you
this
for coming
okay
in.
now? Okay, so the second thing that I'm not going to talk about is the issues which should be contained in primary or secondary legislation. What we do need is for the principles and policies of the issues to be set out in the Parent Act so as to ensure that the legislation is constitutionally robust. What I will do now is just make a brief comment on the issues which I've identified, and then I'm happy to answer any questions or clarify those issues later. The first issue that I've raised in my written submission is that which is key to the decision in A, B and C, and that's how it is to be established if a real and substantial risk to the life of the pregnant woman exists. I argue that this is a decision that should be left to medical practitioners, where the woman disagrees with the outcome, with the decision of the medical practitioners. I also argue that she should have an automatic right of referral to an independent practitioner, which of course is part of best medical practice. In the context of this risk, there is no requirement of certainty that there be a real and substantial risk to the life of the woman. It only needs to be established as a matter of probability. So doctors need to be happy that as a matter of probability, there is a real and substantial risk to the life of the woman. Further, termination is only permissible where it's the only way that her life can be vindicated. So the way the X case operates is a very, very limited way. The second issue, the second main issue I raise is in relation to matters of conscience and where a doctor conscientiously objects to treating a woman. I think that this position should be respected as is respected in line with the Medical Council guidelines. And further, naturally, and of course, the right of a woman to refuse life-saving termination should also be respected in the context of her capacity. The third issue then, which I raise in my submission, relates to fetal viability. I would argue that where medical professionals agree that, as a matter of probability, there is no prospect of life outside the womb, termination of pregnancy should be permissible here. I base this assumption on or I base this opinion on the Roach and Roach decision by the Supreme Court, in which case unborn life was defined as life which has the capacity to be born. So life which has the capacity to be born is that which is protected by the Constitution, and in cases of inevitable miscarriage, for example, or certain cases of lethal fetal abnormality, there is no prospect of life outside the womb here, and so Article 43.3 doesn't apply. In relation to time limits, then, I think there has been some discussion on this, and again, where there's a real and substantial risk to the life of the woman, theoretically, at the very least, termination of the pregnancy is permissible at any stage in the pregnancy. Now, just because we talk about a termination of pregnancy doesn't mean that we're talking about abortion. A pregnancy can be terminated, as it is in the most natural of ways, by the woman giving birth, or it can be terminated by abortion. And where there is a risk to the life of the woman, best medical practice will determine whether a termination of the pregnancy by abortion or a termination of the pregnancy by the birth of the unborn is the best way to proceed here. And again, I would argue that that best medical practice should determine how this is regulated. If we don't provide for this, both lives will be lost, and I don't think that that's what we're trying to do here. The next issue that I think needs to be addressed in legislation is the capacity of a young person to consent to this sort of treatment. I don't think that the issue of abortion should be treated any differently to the way in which a young person generally consents to medical treatment. That said, the law in relation to 16 and 17-year-olds and young people under the age of 16 is woefully unclear. Thankfully, the Law Reform Commission have published a report setting out very detailed recommendations and indeed a draft bill outlining how this issue should be dealt with. And I think that that legislation should be introduced in parallel to this legislation in order to provide a very robust system of treatment, medical treatment for young people. The issue of individuals in care of the Health Services Executive and those for whom proxy consent is required, I think also needs to be addressed. I would also urge the committee at all stages in its proceedings to use value-neutral language and constitutionally appropriate language. We shouldn't talk about mothers. I am visibly pregnant. I'm not a mother. I'm a pregnant woman, and in the same way, we don't talk about children or babies inside the womb. I think we talk about the constitutionally protected unborn or the fetus, and I would suggest that this language be used in legislation as well. Finally, I would suggest that the committee take this opportunity to consider more broadly the impact and scope of Article 43.3 and legislate for some ancillary issues which I have set out for. Of immediate importance, naturally, is the need to implement the recommendations of the Committee on Assisted Human Reproduction. There are other issues which I have highlighted, some of which were highlighted by the expert group. For example, it's not currently a crime to kill a child in the process of being born, and I think that's an obvious gap in the legislation which can very easily be rectified. I think that we need to take a proactive approach here rather than a reactive approach. We didn't think that a teenage pregnant rape victim could be stopped from travelling to another jurisdiction to terminate her pregnancy, but that happened. And I think we need to try and envisage all the possible scenarios which are not directly covered by X, but which will impact on the life of a woman, her ability to travel, and indeed the life of the unborn in this legislation which have emerged following X. They're the issues that I think should be addressed. Apologies for the mic issues at the beginning. Thank you for your time, and I welcome any questions that you might have of me.
Thank you very much indeed, and apologies for interruption in your presentation. Thank you for being here today. I want to now invite Ms. Ciara Staunton from the School of Law, Anyway Galway, to make her opening remarks. Ms. Staunton, you're very welcome.
Thank you. Mr. Chairman, Deputies and Senators, I would like to thank you for this invitation to present to you this morning. Like Ms. Schwepp, I'm working under the assumption that what we are doing is introducing legislation and perhaps some regulations. Guidelines simply are not sufficient to meet our requirements under ABC, and this has been echoed by our own High Court, Supreme Court and various government reports. X, as stated, is that if there's a real and substantial risk to the life of the mother, she is entitled to a lawful abortion. That is the law. Therefore, we have a degree of lawful abortion within Ireland. So for the rest of my presentation, what I'm actually going to discuss is the need to repeal Section 58 and 59 of the 1861 Act, a discussion of the real and substantial risk tests, I want to focus as well in on the risk of suicide and also just some general comments on the procedures for determining when there is a lawful abortion. First of all, we need to repeal Section 58 and 59 of the Offences Against the State Act. Nowhere in those sections do they actually discuss the rights of the unborn or the mother, unlike Article 43.3. So we need to amend our legislation to complement Article 43.3 and also the decision which has come from the Supreme Court since then. Second, the real and substantial risk test should be put on a statutory footing. This is the one exception at the moment which we have to Article 43.3. Like Ms Schwepp said, it's very likely in the future that if facts come before the Supreme Court, we may actually find we have another exception to the general prohibition on abortion. And this committee should be aware that we should perhaps take consideration of these future issues which may arise. However, back to the real and substantial risk test. This is a constitutional exemption and the legislation must give effect to this test. Now, what exactly does this test actually mean? Well, it is very clear that a real and substantive risk does not mean an immediate and an inevitable risk. And Justice McCarthy actually addressed this in the Supreme Court decision in X. So if we want to actually define the test in another way, we can say that on a matter of probability, where there is real and substantial risk to the life of the woman, at some point during the pregnancy, an abortion is lawful in Ireland. It does not have to be proved beyond it does not have to be proved that there would be a definite death and that that death is immediate. It just means that on a matter of probability, at some point, a death is likely to arise. So the matter which this committee has to actually consider is the issue of time limits. Now, it is standard practice in many jurisdictions across the globe that they actually introduce time limits. However, for this very narrow exception, I would recommend that we do not include a time limit, but rather we have to trust the medical opinion of our doctors. So if we want to take, and Dr. Mills probably can correct me on some of these issues, but if we want to take the example of a woman who's 30 weeks pregnant, and her doctors believe that there is a real substantial risk to her life at some point, what she's entitled to is a termination of the pregnancy, because that is what is putting her life at risk. So her doctors must therefore terminate her pregnancy and save her life. Then the doctors should make every effort to save the life of the unborn. And in that way, both the right to life of the mother or the pregnant woman and the unborn are vindicated. It does not mean a death to the fetus. It just means that we first must look at the right to life of the mother and then try and vindicate the right to life of the unborn. So therefore, I recommend that rather than inserting a cut-off point to the legislation, the regulation should actually detail that doctors should save the life of the mother and then do every effort to save the life of the unborn. These are very difficult cases which are going to come before doctors, and we really must trust the clinical judgment of our doctors. The third issue is the very narrow suicide test. This has received a lot of attention in the media and in some of their writings. The real and substantial risk test does include a risk of suicide, but that is only if the risk of suicide arises from the pregnancy, and that risk of suicide can only be averted if there is a termination of the pregnancy. So say, for example, if a woman is pregnant due to rape or incest, if she's suicidal due to the rape or incest, she is not entitled to an abortion. It has nothing to do with the pregnancy. However, if her doctors actually believe that her risk of suicide arises from the pregnancy, which has arisen from the rape or incest, and that risk of suicide can only be averted by a termination of pregnancy, it is then that she is entitled to an abortion, and only then. So therefore, risk of suicide cannot be excluded from any of the medical issues. Medical issues and suicide are to be treated as one and the same and go under the exact same test. Finally, the procedures for determining a lawful abortion. First of all, legislation has to take account of the real and substantial risk test. And I'd also echo comments that really this is something that's best left up to our medical doctors. By putting this statutory defence into legislation, we are telling our doctors we will not criminalise them if they perform an abortion where they believe there's a real and substantial risk to the life of the mother. So it's taken away that chilling effect which the European Court of Human Rights actually discussed in the ABC case. The second issue which the legislation was taking account is the issue of conscientious objection, which was raised by the Medical Council yesterday. Legislation should take effect of this, and this is common practice internationally, but it should be with the caveat that the conscientious objection can only arise where there is another doctor willing to perform the abortion. A woman's life should not be put in jeopardy because the doctor is unwilling to perform the abortion. And finally, I would like to repeat that the issue of time limits should not be put into legislation. Really, what should be the overriding theme of this legislation is that we should respect the clinical judgment of our doctors. We respect the clinical judgment of our doctors in all other cases, and this abortion should be no exception. I welcome any questions that the committee may have on any aspects of my presentation. Thank you.
Thank you very much, Ms Staunton. I want to welcome now Mr. Simon Mills from the Law Library. Mr. Mills, you have 10 minutes. Thank you.
Thank you, Chairperson, Deputies and Senators. Thank you very much for inviting all of us here to set out our views on the law relating to this matter. I just want very briefly, because I suppose I have a slightly unusual background for the purposes of a legal session, I just want to very briefly set out a little bit about my own background and a little bit about the background on which my submissions are grounded. And my submissions are somewhat different from Ms. Reps and Ms. Staunton's, although I should say that I agree with almost everything that both of them have said. And in fact, in relation to one of my views, I've actually been persuaded to change my mind on something, and I suspect we may touch upon it later on. But the step that I have taken is a somewhat unusual one, in that my written submissions are a proposed draft bill for the termination of pregnancy in accordance with Article 43.3 and in accordance with existing Supreme Court jurisprudence, including, but crucially not limited to, the X case. My professional background is that I'm currently a practicing barrister and have been since 2002, and I specialise in all areas of healthcare law. But as well as that, from 1997 till 2011, I was a practicing doctor, and for most of that time, I was a part-time general practitioner in an urban setting. And it may be helpful to the committee and the other deputies and senators present to know that during that time I dealt with a small but significant number of women who were seeking termination of pregnancy. And I retired as a medical practitioner in 2011. I no longer practice medicine. And as well as being a barrister and a doctor, I also completed an MSc in philosophical medical ethics, and perhaps presciently enough, I did my thesis on the topic of legislating for abortion in a pluralist society. I just want to say something very briefly as well about the debate that has brought us here. And for the purpose of the present discussion, which I hope is a dispassionate analysis of the law in relation to the termination of pregnancy, I adopt no position one way or another on the question of abortion. But I do want to observe one thing, which is that in general, public discourse on the question of termination of pregnancy, and these hearings are a notable exception, I think, judging from what I heard yesterday, very often frames the political and social debate as if it were a two-sided issue. And in public discourse, there's an apparent assumption that the only conversation that is to be had is between, and one always would prefer to avoid the divisive terminology, but between the pro-abortion / pro-choice side and the anti-abortion / pro-life side. And on this account of matters, it is assumed that pro-life means no more and no less than being opposed to abortion in all circumstances, and that pro-choice means no more and no less than ultimately being in favour of abortion on demand. I believe, and have always believed, that this is simply an inaccurate model, and that views of abortion are much more complex than this sort of simplistic analysis tends to suggest. And I think, in fact, that the constant reinvigoration of this old account of abortion debates, characterised by pro-life versus pro-choice, has continually frustrated the attempts to move, in effect, from rhetoric to resolution on the topic. I think that a far more realistic account is that abortion is a three-sided discussion. 1, the strong pro-life position, 2, the strong pro-choice position, and 3, the moderate position, which attracts adherents from both pro-life and pro-choice side. And if there's a majority position on abortion in this jurisdiction, and I believe there is, I suspect it is that which frames really the majority view on abortion in this jurisdiction. That substantial overlap between moderate pro-life and moderate pro-choice. And the step I have taken for the purposes of, I hope, assisting the committee is to draft a termination bill that I hope steers a middle course between constitutional proprieties and the needs of women in this jurisdiction. The draft termination bill which I've prepared arose firstly from a need to clarify in my own mind what sort of legal regime would be permissible in Ireland, having regard to the Constitution, and secondly to establish whether such a regime was amenable to being drafted in a compact and comprehensible legislation. I think there would be some irony if we came before you as lawyers today to say that you must legislate without at least having given some thought to how that might work, because you can guarantee that were you to draft unworkable legislation, we lawyers would be the first people to pull it apart. And I hope that the legislation will at least provide a template for discussion. I don't presume it amounts to any more than that, save for a number of things. First, I believe it accurately reflects the state of law in this jurisdiction, with one qualification, which is in relation to viability, which the bill as drafted, I think may need some thought, and I bear in mind in that respect the comments that have already been made by Ms Schwepp and Ms Staunton, with which ultimately I agree, and which I think are not accurately reflected in the way the relevant section is drafted. Secondly, I believe that it provides the clarity that the medical profession has said it has been looking for. Thirdly, I believe that it provides many of the safeguards which are required by those who are sceptical for the need for any codification of law allowing for termination of pregnancy. And in particular, there is no scope in the bill, on my reading of it and on the reading of those to whom I have showed it, for any scheme of abortion on demand. Fourthly, I believe it meets the recommendations of the expert group insofar it provides for the combination of legislation and regulations. Fifthly, I believe that it's a bill to which all political parties who have called for the codification of the law on termination can subscribe on the basis of their public pronouncements. And lastly, I think it provides a clear basis for legal terminations within the scope of Article 43.3. There are some things the draft bill does not include. It does not include anything to do with rape or incest, that is, pregnancy occasioned by illegal circumstances, because it seems to me that Article 43.3 precludes that, save in the circumstances identified by Ms Staunton, where by reason of the pregnancy occasioned by legal circumstances, there is a threat of suicide. And I adopt and agree with the remarks made by both Ms Schwepp and Ms Staunton on the question of legislation for suicide. Very briefly, I just want to set out what the bill contains. Sections 1 and 2 deal with a number of limited preliminary matters, including certain definitions. In Section 3, the legal position in relation to the 1861 Act is restated in modern language, with alterations to the length of custodial sentences, in line with the last referendum on the question of abortion and the draft bill contained therein. However, having restated the legal ban on abortion, the bill goes on to set out a number of clear exceptions, under which a termination will not be unlawful under the restatement of the 1861 Act. First is the scenario where termination arises as a consequence of other medical treatment. That's Section 4. Sections 5, 6 and 7 deal with the question of the real and substantial risk to life, including the threat of suicide. Section 7 specifically deals with the threat of suicide, and it applies, as Ms Staunton called for, the same test, albeit a test executed through a slightly different two-step process, in order to give, I think, assurance to those who have certain concerns about the threat of suicide. Section 8 deals with termination of pregnancy in cases of inevitable miscarriage of a non-viable pregnancy, which was touched upon by Ms Schwepp, and again, I agree with her that I think that the non-viable pregnancy comes within the remit of a permissible abortion within 43.3. Section 9 deals with the termination of pregnancy in cases of lethal fetal abnormality, and again, I adopt and agree with the remarks of Ms Schwepp on that front. Section 10 deals with the power of the Minister to make regulations as to the certification of medical opinions, and all of the grounds that I have set out would all be certified on the basis of not fewer than 2 medical opinions, one of which must come from an appropriately qualified medical specialist. Section 11 affords certain immunities to doctors acting in good faith under the Act, consistent with the wish expressed yesterday by, among others, Dr. Mahoney from Holles Street Hospital, and it also imposes certain obligations on doctors to act in good faith. Section 12 contains an express ban on the termination of a fetus which is viable, and that is the section which I touched upon earlier on, which may need some modification in the light of the submissions of Ms Schwepp and Ms Staunton, which I accept. Section 13 allows, again, bearing in mind the comments of Dr. McCaffrey yesterday before this committee, it allows for conscientious objection on the part of doctors and in certain circumstances on the part of nurses. Section 14 provides for locations where terminations may take place, including the entitlement of the Minister to make regulations providing for such locations and providing for the reporting of terminations by such locations. And Section 15 makes the provision of any information relating to terminations which would be lawful under the bill, makes the provision of that information also lawful. Section 16 provides for certain penalties. Section 17 gives jurisdiction to the High Court to deal with disputes. And Section 18 repeals certain matters, most notably Section 58 and Section 59 of the Offences Against the Person Act 1861. I believe that the draft bill will not necessarily commend itself to the doctrinaire elements of either the pro-life or the pro-choice groups, but I do believe that it amounts to a convincing first stab at a law built on a common ground and built around a consensus, and in an attempt made in good faith to move the discussion on, as I mentioned at the outset of these opening remarks, from rhetoric to resolution. And I, again, as with the other contributors, happy to take any questions the committee may have.
Thank you very much indeed, Dr. Mills. Okay, it's 60-minute session now for members of the committee, and I'll ask Deputy Keller to commence.
Yeah, just very briefly, just to welcome the witnesses and thank them for their presentations. Just very briefly at the outset, with regard to the X case and its findings and the jurisprudence as outlined by the witnesses, just with regard to fetal abnormalities, I mean, this is a very sensitive issue, and we've had presentations from women who have had to travel to England to terminate a pregnancy because there was no potential viability at birth. And are you saying, Ms. Schwepp, that it is not necessary to have a constitutional change to address this particular issue if it was deemed acceptable to address through legislation? Because I think that's something that a lot of people have been speaking about in a very emotive way in presentations that we've had, that they're being forced to travel to England to have a termination, and are you now saying that a referendum wouldn't necessarily be necessary to allow legislative changes if it was so deemed suitable or appropriate?
Well, Gordon Mahagat, and I'd like to join with you, Chairperson, in welcoming our 3 guests here this morning, and I thank them for their considerable contributions. If I could just try to tease out a couple of other areas, if I may. Jennifer, in your considerable document that you had presented to us beforehand, and I know going on to recommendation 3, I think, in your document, on page 16, you're talking about adults of sound mind refusing treatment. I'm making reference to that in particular, and you make reference to the exception that arose where Justice Lafoy talked about and sought a capacity test. In preparing legislation and what is actually to be done as a result of all of these deliberations, you know, yesterday I tried to tease out the challenges of having precision in legislation, and the scope of legislation is what I'd like to ask of you here. We will never be able, obviously, to second guess or anticipate all the situations that can and over time undoubtedly will present. But do you believe that the legislation now to be drafted should anticipate and provide clarity for medical practitioners where there is agreed professional opinion that the woman has not the ability or is not of sound mind and is not capable of making a decision to refuse medical intervention. I'm interested just to invite your elaboration on that particular point to inform just the extent of what you might wish the legislation to address. In relation to Ciara's presentation, and again, it's just clarity that I'd like, Ciara, in relation to your point. When you speak of the narrow suicide test, point 3 in your own presentation, are we looking at the current legal position when you speak of a pregnant woman who is suicidal for reasons not directly linked to the pregnancy is not entitled to an abortion? However, if her suicidal tendencies are due to the pregnancy, she is entitled to an abortion. Is that the current legal position? It is reflected, as I pointed out yesterday, when the Medical Council representatives came before us, it is in their guidelines. But it's quite evident to me that not everyone is aware of that being the case, including expert opinion that presented here yesterday and may yet present before these hearings later today or tomorrow. And certainly not all legislators are aware of the fact. Could you just be clear about that situation for us? And lastly, and there's very little time, unfortunately, and the Chair will ring his bell, I'd just like to, first of all, Simon, say to you, that I commend your drafting skills. I've gone through the legislation that you have offered us, and I welcome and thank you for the effort employed. Now, I just want to go back to the point that Deputy Kelleher raised, and this is just my final observation. In the draft legislation that you have offered us, you do in fact include provision for the termination of pregnancy in the case of lethal fetal abnormality. There is an assumption, and it was in evidence in the discourse last night on the Vincent Browne show on TV3, that this is something that cannot be addressed in the context of the legislation now to present. I'm not convinced that that's the case. And while it is the case that the committee have made a decision not to accommodate those who wanted to articulate their very disturbing experiences, and they are most certainly, and as the young woman spoke last night on the programme, I mean, how could anybody not be moved by the situation that she and her partner have been through, and the many, many other families? So I just asked, the Chair is anxious to hit the bell on me, I just asked Simon if he could indicate across his undoubted skills, if it is within our compass to include provision for this particular matter in the now to present legislation.
Thank you, Deputy. And let's hear Deputy Ciara Conlon.
And to thank the witnesses for their submissions and for making their presentations to us today. Again, I would echo and would welcome some feedback on the questions that have been posed in relation to the fatal fetal abnormalities and how you feel that that can be addressed. And I'd be very interested to hear about that. Ms. Schwepp, in relation to your presentation, you make some, I think, very valid points in relation to the capacity of young people. And let us not forget what the X case was about. It was about a 14-year-old child and her wish for a termination due to an unlawful pregnancy. And I'd like maybe for you to tease out a little bit more about that. And I'm not sure that people and maybe the public are aware of the quandary that children in care find themselves in terms of the status of their care order and how that might prevent them from getting the timely treatment that they so may require because maybe of the chaos of their family life and because of the chaos that sometimes they find themselves in the care system. And I think that's a really valid point because they're a very vulnerable young group of people who often can find themselves in a crisis situation in relation to crisis pregnancy. So I think it's a really welcome interjection into the debate and one that we haven't heard And I think that one that will probably find itself to be a test, you know, of all the tests, it's one of the most likely, because it's a very high-risk group. And so I'd welcome some further clarification in relation to that. There's also been some debate in the public and by commentators in relation to the repeal of the sections 58 and 59 of the 1861 Act, and Ms Staunton, you referred to this in your presentation, and there are some discourse now starting to emerge that this it's not as simple as to just repeal that in terms of dealing with old law, that something must replace it. And if we legislate for X, will that be enough? You know, is there some sort of other quandary? Are we going to have another gaping hole in our legislation in relation to sexual health and reproductive rights? And will there still be some ambiguity there if we were just to repeal those sections? And I'd welcome some further information on that. In relation to the suicide test due to pregnancy, I think, you know, for me, that has really clarified it in the submission that you make, that it's not due to an unlawful pregnancy, but as a direct result of the woman being suicidal at the thought of being pregnant. I mean, for me, that's very clear, you know, and I think that's a very welcome, I think, into this debate. And I'd welcome some of your thoughts in relation to how we do that as legislators. So I welcome your feedback, and I may come in again with the Chair's permission. Thank you.
Deputy Seamus Healy, sorry.
Thank you, Cathaoirleach, and to thank the witnesses for their submissions. I think they've been very helpful, and particularly Dr. Mills's indicative bill, a very interesting template, I think, in relation to this whole subject. I just look for some clarity, first of all, on if the witnesses might explain to the committee the current legal position in relation to this issue. Was clearly what you understand the current position to be. What your position is in relation to the expert group's report. Is it your position that you support the legislation and regulation option? Thirdly, the question of conscientious objection in relation not only to medical personnel, but for instance nursing personnel and other personnel. Yesterday afternoon I raised with the Institute of Obstetricians the whole question of fetal abnormality and whether that can be seen as part of the legislation. Now, it's a question you've touched on. I'd like you to clarify and to expand on that, please. Finally, the whole question of children and adolescents and the question of consent in relation to that. Thank you.
Thank you, Deputy. Ms. Schwepp, if you want to start, please. Start with Dr. Mills.
Sure. I'll answer them in order, if that's okay. I know there's some of them overlap, so I'll deal with them as the issues came up. In relation to the issue of fetal abnormalities, which was raised by Deputy Kelleher, my position on this is, and I think that I'm correct in stating the law as to be, where the fetus has no capacity to survive outside the womb, that is not life for the purposes of Article 43.3. So when we talk about unborn life in the Constitution, what we're talking about, as Mrs. Justice Denham, or Chief Justice Denham as she is now, stated in the Roach and Roach case, we're talking about life which has the capacity to be born. Now, in that case, it did relate to embryos, so embryos which are implanted in the womb. But I think that her reason and her logic in relation to what the Constitution protects and what it doesn't protect, I think applies in relation to fetuses which have absolutely no capacity to be brought to term and to produce a living baby. I don't think that Article 43.3 applies there. perhaps as a matter of clarity, the legislation should, in a declaratory manner, state that. But I don't think we need a constitutional amendment where, as a matter of probability, doctors are of the opinion that the fetus has no capacity to be born. I think that that's the legal situation. The problem, I guess, arises where doctors are of the opinion that the fetus has the capacity to be born, but that it will only survive for a short period of time, be it a matter of days or a matter of weeks. Tragically, I think that in circumstances such as that, the Constitution does not permit termination of pregnancy, and unfortunately women in that position do currently need to travel to terminate those pregnancies. I don't agree with this position. I didn't see the Vincent Browne show last night, but I think that a constitutional amendment would be required in those cases where there is prospect of life outside the womb, where the pregnancy is a viable one, but where we talk about inevitable miscarriage, as Dr. Mills talked about, or where we talk about where the fetus has no capacity to be born alive, so adopting the born alive rule, I don't think a constitutional amendment is needed. I do think that the legislation should include a declaratory statement to that effect and permit medical practitioners to terminate pregnancies in those circumstances. I hope that answers your question. Deputy O'Quailon, your first question related to refusal of treatment. I guess as an academic, I like to think of all eventualities. So that was something that I just included there because I suppose we assume, or the rhetoric, the debate assumes that where there is a risk to the life of a woman that she will want to terminate her pregnancy. That isn't necessarily always the case. So I just wanted to highlight the fact that some women will say, yes, I know my life is at risk, but I still want to continue with that pregnancy, and I would like the medical practitioners involved in my care to try and see that pregnancy through. The only exception, as I see it, to that general position, which is a general position in law, this doesn't just apply in the context of termination of pregnancy, is where the woman doesn't have the capacity to refuse that treatment. The Fitzpatrick case would be a very, very narrow exception to that. And again, I would suggest that the Law Reform Commission's recommendations in relation to capacity for vulnerable people generally and for people altogether should be adopted in that context. But this just, my position on that reflects common medical practice. I don't think we need to do anything new there. In relation to the link between suicide and pregnancy, I wholeheartedly agree with Ms. Staunton's position. Just because you're suicidal in pregnancy doesn't justify termination. The threat of suicide must be linked to the pregnancy, and I fully adopt her position on that. Deputy Connell, I think of...
Deputy Conway.
Sorry, I can't see your name. I'm sorry, Deputy Conway. I fully adopt your position in relation, or I've mentioned the issue in relation to fetal abnormalities. In relation to consent for young people generally, the Law Reform Commission have published a report, and I would commend it to the committee. It's very, very detailed. It sets out exactly what the legal issues here are and recommends very robust legislation for dealing with it. Quite simply, in relation to 16 and 17-year-olds, there seems to be a presumption currently in Section 23 of the Non-Fatal Offences Against the Person Act that a 16 or 17-year-old can consent to medical treatment in the absence of parental consent, though it would appear that Section 23 only provides a defence to a doctor in the case of criminal sanctions as opposed to civil sanctions. For those under the age of 16, there is a presumption against treatment in the absence of parental consent. I think this is an issue which needs to be addressed. I refer to a paper by McMahon et al. Where they talk about GPs' utter confusion as to whether or not they can treat somebody under the age of 16 for anything. Again, this doesn't necessarily just relate to this issue. For a broken leg, whether they can treat a 15-year-old for a broken leg in the absence of parental consent. And I think that the Law Reform Commission's proposals are very clear on this issue. When it comes to children in care, I think you're right that this is an issue which deserves that little bit more attention. These young people are by definition vulnerable, and they are treated in law very differently to children who are in the care of their parents. A child in the care of their parents can be brought to another jurisdiction to terminate an unconstitutional pregnancy. Children in the care of the HSE cannot, according to the decision of Mr Justice Gagan in the C case, although the decision of Mr Justice McKechnie in the D case does seem to throw a little bit of confusion into that entire issue, and I think that needs to be teased out. The current legal position, sorry, Deputy, the final Deputy there, the
Deputy McGrath.
Deputy McGrath, sorry.
Oh, Healy, sorry, beg your pardon.
Healy,
sorry.
sorry.
My apologies,
I
Deputy
thought
Healy,
that's
sorry.
what it
My sincere apologies. Mistake you. Sorry. Apologies.
The current legal position is that termination of pregnancy is constitutionally permissible where there is a real and substantial risk to the life of the mother, and where that risk can only be eliminated by termination of pregnancy. That risk has to be assessed as a matter of probability, or has to be determined as a matter of probability. I agree with the expert group that legislation and regulation is required. In relation to conscientious objection, I would simply adopt the current position which is set out in the guidelines, but I think that shouldn't be made clear again for declaratory purposes in this legislation. I've dealt with fatal fetal abnormalities, and I think I've already answered your question in relation to children and adolescents. So thank you.
Okay. Ms. Staunton, and we have 6 other members who want to speak as well, so if you can... Thank you.
Well, Deputy Kelleher, while you didn't address the question to me, I would just like to make the comment that when drafting the bill, we do have to take into considerations of cases which have not yet been litigated. The X case is the only exception we have at the moment, because that is the only case which actually has been litigated. So I think this committee needs to be very careful when drafting legislation to take account of these cases which we have discussed. Like, after all, we do not want to come back here again when another case has reached the Supreme Court and have another 20 years wait in which we actually see the introduction of legislation. On to the narrow suicide test raised by Deputy Quaylen. The test is that there is a real and substantial risk to the life of the woman. The reason why I have mentioned suicide on its own is just simply because there's this fear that there will be floodgates. That fear is completely unfounded, and it suggests that there will just be some sort of collusion between the pregnant woman and the doctor. That is not the case. We trust our doctors in every other clinical judgment they make, and we must continue to trust our doctors when it comes to the issue of abortion. It is very clear that it's only if the risk of suicide is linked to the pregnancy, that case there is a lawful abortion. To Deputy Conway and your discussion on why we should appeal Section 58 and 59, I recommend that we should repeal Section 58 and 59 because it's outdated. It does not take account of Article 43.3 and the subsequent High Court and Supreme Court decisions. And furthermore, it makes no reference to the right of the mother and the right of the unborn. It focuses in on abortion, so I say we should appeal it, but replace it with something else. If the House wants that there should be criminal prosecution for an unlawful abortion, fine, introduce it, but just have one comprehensive legislation dealing with lawful and unlawful abortion, which reflects Article 43.3 and the X case and any other issues that the House may wish to discuss. On to Deputy Healy. The current legal position is if there's a real and substantial risk to the life of the woman, she is entitled to a lawful abortion. Be it a medical risk or suicidal risk, it's irrelevant. If the risk is directly related to her pregnancy, an abortion is lawful in Ireland. The view of the expert report, I wholeheartedly echo Ms Schwepp. Introduction of legislation to give effect to it, accompanied with regulations. Guidelines simply do not work. They do not have the force of law. Doctors are under no obligation to follow them. And if they are, we're basing on medical council guidelines. There is no right to a lawful abortion if a woman needs it. All the medical council guidelines currently state is that doctors can perform abortion, but there is no right for a woman at the moment to have an abortion. Legislation will ensure that that gap is overlooked. Fatal fetal abnormality, I wholeheartedly echo Ms Schwepp. I'm not going to comment on any more. All I will say is that if there is no risk to life, if there's no possibility that the unborn will produce a live birth, there is no right to life to vindicate, and I believe that abortion is lawful. However, unfortunately, if even that child has the possibility of being alive for even a second, unfortunately, a pregnant woman cannot have an abortion in that case. It's irrespective of the time, it's not about quantity or quality, it's about the fact that it is capable of being born, and that's where the test should lie. And on to the issue of children consent, the Law Reform Commission has actually recently published a report on this, and in particular they focus in on the 15, 16, 17-year-old age group, which is very important when dealing with this, and I would recommend that the House reads that, considers it, and proceeds based on their recommendations. Thank you.
Thank you. Dr. Mills.
Thank you, Chairperson. Deputy Healy's are perhaps just a useful jumping-off point for me to reply to the totality of the questions. The first question he poses is, well, what's the current legal position? I think there are two aspects to the answer of this question. One of the aspects has already been furnished by Ms. Schwepp and Ms. Staunton, which is, well, what do we know from X? And that's already been set out. But I think there's something slightly more to the answer to the question is, what can we also reasonably infer from the text of Article 43.3, from other Supreme Court decisions, and in particular the Roach decision to which Ms. Schwepp has already adverted, and also decisions of the European Court of Human Rights. And one relevant decision is the decision that was handed down in the case of D versus Ireland, in which, as it happened, the Court of Human Rights found that the complaint was not admissible, but they made certain pertinent observations in relation to the case of lethal fetal abnormality. And I think there are things that we can infer from the state of law in general, and it is a mistake to confine our consideration of this to X, notwithstanding the terms of reference of this group, for two reasons. The first has already been identified by Ms. Staunton, which is the X case was about X. That's all it was about. That's all the court was asked to decide. One can think of recent cases in this jurisdiction where, if they had come before the courts, one might wonder what the courts would have decided. And then we would be talking not just about X, but about E, about F, about G. It is simply a fact of our proximity to the United Kingdom that more cases have not come before the courts. That would amply identify, in my view, the number of circumstances in which terminations are permissible within the meaning of Article 43.3 and in a manner that is consistent with existing Supreme and High Court jurisprudence. And that's the second limb. So the first is what we know from the Article 43.3 and X case, and the other thing is, well, what can we infer? And what we can infer, among other things, from the Roach decision, and in particular the judgment of the now Chief Justice, Ms. Justice Denham, is that the meaning of life, so you'll hear more about the meaning of life from the church leaders tomorrow, but the meaning of life in a constitutional sense is to do with the capacity to be born alive. And that is the basis, for example, why the draft bill that I've prepared for you includes two specific provisions. The first is in the case of the inevitable miscarriage of a non-viable fetus. By non-viable, I mean incapable of surviving by reason of its prematurity. And also the case of the lethal fetal abnormality, which is that fetus or embryo that is incapable of surviving outside of the womb. And unfortunately, I have to agree, I think, with Ms. Staunton and Ms. Schwepp about the fetus that will survive for a few moments outside the womb, or the baby that will survive for a few moments outside the womb once born. I have to say that I think there is something disturbingly utilitarian about Article 43.3 in that it comports an obligation to be born only to suffer and die, where the wish of a caring and prudent and loving parent might be for a different outcome. But that, I think, is not a matter for this committee to consider. My position on the expert report is, as with Ms. Schwepp and Ms. Staunton, I think it is the best of the four options, is the last that was proposed and recommended by the expert group, namely a combination of legislation and regulation. And that's why the draft bill, again, that I have prepared for the assistance of the committee, provides for both legislation setting out a broad framework and the entitlement of the Minister to make certain regulations in relation to certain aspects of the operation of the Act for its smoother and better operation, and in order to respond to any exigencies that may arise. The question of conscientious objection, this is clearly set out in the Medical Council guidelines. However, I do think that it requires express statutory provision. And again, it is specifically provided for in the draft bill that I furnished to the committee. And I deal with conscientious objection in that bill in two ways. Because the termination of pregnancy under that bill or under any bill will be a two-step process. The first step will be the provision of opinions that are sufficient to ground a lawful termination, and the second step will be the performance of the termination itself. And what I say in the bill is that in relation to the provision of opinions, which must be provided under the bill by a registered medical practitioner, a registered medical practitioner has a right of conscientious objection, subject only to an obligation to refer a person on